Corporations. Excerpted from Nemesis. The Jouvenelian versus the liberal model of human orders. 2019. Cigar. As we have seen in previous chapters, across many disciplines there is a persistent and pervasive lack of awareness of the role played by structures of authority in cultural developments, and this has been exacerbated by the structural centralization that underpins modernity. One key element of this process is the supposed distinction between the private and public spheres of existence, a concept which has become a core constituent of modern political reality. On one side of this distinction is the public realm of governance, and on the other is the private realm, which is comprised of the individuals in society and other elements such as corporations. Upon close inspection, this distinction between public and private is, yet again, revealed to be anything but timeless, maturing into its modern incarnation as late as the 19th century. The ways in which these realms interact, and the border between them, differ between political ideologies, but that there is a public/private distinction is a constant. Operating within this tradition in a somewhat odd way are the various anarchisms that recognize this split and demand the total renunciation of the public realm. Note that these strains of anarchistic thought do not deny the validity of these categorizations, they simply demand the abolishment of one of them. This distinction creates a situation wherein it becomes evident, as it does in modernity, that the impact of authority on the very makeup, epistemological, linguistic, ethical, psychological, etc., of the agents in this society goes unrecognized. The individuals in society, and society itself, have come to be understood as natural and spontaneous, but ultimately ordered, Locke, or disordered, Hobbes, but in any case, this private realm is not seen as intrinsically connected to authority, an authority which is, therefore, external to it, and must be created. As a result, we have governance, civil society, and, in more recent times, we also have the development of something which has been called an economy. The definition of an economy, as with all of these concepts born and sustained by structural conflict, typically differs according to time and context, but overall, these various definitions tend to agree that the economy is, in some sense, an autonomous area of production, trade, and consumption, devoid of greater meaning. The concept of the economy is usually attributed to Adam Smith, but the French physiocrats predate him, and developed a number of concepts fundamental to his thought, especially the idea of an arena of natural liberty comprised of individuals that operate independent of authority. From any angle but that of the Jouvenelian model, it would seem odd that the economic order would be a development of the physiocrats. It is a matter of record that the physiocrats wished to put the King of France into a position that could best be described as that of an Oriental despot, and that they prized an agricultural society. So great was the influence of Confucius and the Chinese imperial system on François Quesnay that he has been labeled the Confucius of Europe. Quesnay even went so far as to propose the widespread adoption of Chinese institutions, and wrote a book on the topic entitled Le Despotisme de la Chine. The creation of such an order was supposed to allow the existence of a laissez-faire economic realm, within which a quasi-natural order under the benevolent guidance of this despotic centralized monarchy could flourish unencumbered by the aristocracy and the church. In contrast with more modern accounts of laissez-faire that practically do away with the role of government, the physiocrats were overt and enthusiastic supporters of this centralization of power, on the premise that they believed that this order could not exist without this centralized governance. This reference to the need for a central political order is important to note, as this implies an order opposed to the distributed authority of the existing order of the period. Evidently, the physiocrats were producing ideas palpably in support of the monarch's court as the sole authority within the power structures of France. In recognizing that the physiocrats were heavily connected to this centralization, we can avoid the mistake of believing that mercantilism, the system opposed by the physiocrats, was the favored system of the monarchy, and that the physiocrats were in some way anti-monarchical. Quesnay, the fountainhead of this school of thought, was a physician in the court of King Louis XV, and could hardly have produced his work if it was in any way unpalatable to the king's court. Given this, we should be unsurprised to find the following line of argument from a notable physiocrat. Latresne argued, for example, that the absolute monarchy had tamed the nobility and presented royal justice to the people as a guaranteed refuge and a shelter, which is always open, against violence and oppression. Moreover, achieving autonomy from the nobility, the absolute monarchy established the most solid constitution, the one most appropriate to administering the laws of the natural order. The unmistakable conflict between the monarchy and the subsidiary structures of the nobility, here referred to as being for the benefit of the people, is purely Jouvenelian. The next step in the development of the concept of the modern economy was the introduction of this anarchistic ontology into English thought in the form of Adam Smith's The Wealth of Nations. Smith's work would come to the fore with the anti-Corn Law movement of the 19th century, And, in light of this, it would be worthwhile to analyze briefly this movement to see if it doesn't also mirror the physiocrats' success on being supported by a centralizing power. In 1839, the Anti-Corn Law League, espousing Adam Smith's economic thought, was created in Manchester, England, with the express purpose of pressuring the British government into repealing the corn laws which concerned restrictions on the importation of corn. The image passed down to us of the Anti-Corn Law League is that of a brave David, representing free trade, fighting against the Goliath of vested interests in the form of the landed aristocracy. Yet, the funding figures for the movement and its opposition belie this. By 1845, the Anti-Corn Law League had managed to generate an annual fund of £250,000. In the same year, the League's most prominent group managed to raise a mere £2,000 to fund its activities. This vast funding glut for the League was not supplied by the working poor in whose name it was supposedly speaking, but by a financial elite centered on the cotton textile manufacturing sector. In the following year, 1846, funding ceased due to the successful repeal of the Corn Laws, which rendered the movement superfluous, and which put the agitators out of paid positions, as Anderson and Tolleson note. The League dissolved basically because by 1846 its financial support had begun to dry up. McCord, 1968, page 204. The League leaders and agitators did not suddenly lose interest in political issues, but many of them lost paychecks as employees in League offices. It was this anti-corn law movement that obtained the support of centralizing power in the form of Parliament, and not the agricultural elite who were sliding into irrelevance. This thought system was clearly a weapon in a fight over political centralization against an intransigent nobility. Both the physiocrats and the Anti-Corn Law League are clear examples of idea systems being thrust into prominence by patrons, only to be abandoned when they are no longer needed, or when the patrons are no longer in power. In the case of the physiocrats, this patron was the French monarchy. In the case of the free trade advocates of the Anti-Corn Law League, this was the British Parliament, or, rather, a dominant industrial section of the British Parliament headed by Prime Minister Robert Peel. Even though Peel was not directly connected to the League, he was perfectly happy to align with it when it suited him in his centralizing efforts, and his advocacy of centralization can be seen in the various policies he pursued, such as the Income Tax Act, 1842, the first ever imposition of an income tax in peacetime. Peel, famously, was also behind the creation of the modern police force with his introduction of the Metropolitan Police Act, 1829, hence Bobby, the colloquial British term for policeman, in reference to Peel's given name. This all stands rather at odds with the individualism and liberty of free trade that is the hallmark of Adam Smith's economics, but from the Jouvenelian angle, it makes perfect sense. Expansive power always promotes anarchistic appeals to the individual while it is expanding its own reach further into the order in question. The anarchistic claims are applicable to other power centers, but not to the centralizing power center itself. The logic of an expansive government apparatus promoting anarchistic thought of this kind is also found when we move into the 20th century with the full development of the concept of an economy in the contemporary sense. Here, we find the progressive regimes of the British Empire and the United States on the scene, and in the process of another great wave of centralization. As part of the expansion of federal governance by Franklin Delano Roosevelt's government, the American progressive elite began to develop a number of claims regarding the scientific management of society which were mirrored in the British Empire, something we shall see in more detail in Chapter 8 with the development of political science. To this end, a Dr. Stephen Kuznets was tasked by the Department of Commerce to develop a way to quantify the productivity of U.S. industry in order to assist the federal government in understanding the causes of the Great Depression. In response, Kuznets developed the concept of gross national product, GNP, which would be superseded by gross domestic product, GDP, in 1944. The concept of something called the economy that could be measured by GDP then became common usage. Another way to frame this narrative is to point out that this was a centralizing power center expanding its reach and promoting a mode of thought which lent an air of scientific legitimacy to this expansion. The removal of subjective elements is a major necessity in this task, so the subjective, apolitical, and measurable economy was carved out of the order as part of this process. At this point, this development encountered a major problem in that the corporation, the cornerstone of modern commerce, does not cohere with the concept of an economy. The exemption of the corporation from the logic of free trade and individual autonomy became a pressing intellectual problem. The corporation had, therefore, to be explained in a manner that would warrant its existence within this anarchistic scheme, and this was provided by Ronald Coase's celebrated explanation for the existence of the firm. In the nature of the firm, Coase attempted to explain why organizations in the form of the corporation come to be, Given that it is usually argued that coordination will be done by the price mechanism, or, in other words, to explain why we have a firm at all if the market can organize us in an individual-based, spontaneous, contractual manner by the use of the price mechanism. Coe's answer to the problem was to claim that in some instances organization without the price mechanism is more cost-effective. Coe is to be commended, because in his paper he makes his premises very clear. He takes the concept of the specialized exchange economy as a starting point, and establishes that he is considering man in light of Adam Smith's anthropological account. This, however, does not excuse Coe from failing to recognize that the concept of an economy is intrinsically linked with centralizing power, and is not a brute fact from which we can reason. The contractual theory of the corporation, based as it is on the economic individual that underpins Coe's account, was taken even further in the 20th century by the Chicago School of Law and Economics, headed by Milton Friedman. The Chicago School began to popularize a theory asserting that the business corporation is merely a nexus of contracts between individuals, something also known as the contractual or aggregate theory of the corporation. This is in stark opposition to the artificial theory which holds that the corporation is a creation of the state. There is a third version, the real theory, which holds that the corporation is an entity that is real, yet separate from the state and formed by individuals, but this is, in essence, a weaker version of the aggregate theory, in that these two theories consider the corporation to be formed from a ground-up process without reference to authority. This ontological claim precludes the corporation from being created by law, and places it firmly within the realm of spontaneous civil society, or the economy. We can see this clearly in Friedman's Capitalism and Freedom, where we find Friedman making the following claim. Fundamentally, there are only two ways of coordinating the economic activities of millions. One is central direction involving the use of coercion, the technique of the army and of the modern totalitarian state. The other is voluntary cooperation of individuals, the technique of the marketplace. The reader should note that Friedman has made a glaring omission in this passage, as he has simply put forward the market as the Western model. Of course, he does correct himself in later pages when he concedes that the existence of a free market does not of course eliminate the need for government. On the contrary, government is essential both as a forum for determining the rules of the game and as an umpire to interpret and enforce the rules decided on. But this means his initial statement regarding the two ways of coordinating the economic activities of millions should be adjusted, and instead of positing the marketplace as the opposite of central direction involving the use of coercion, the technique of the army and of the modern totalitarian state, it should be the marketplace under the control of the liberal state. This makes clear the usefulness of anarchistic thinkers such as Friedman to centralizing power. Government becomes a public forum and an umpire in service to this private free market, as opposed to being an actor forcing the concept of a free market into existence, just as a corporation is rationalized away as a matrix of individuals. In framing the corporation as the result of this spontaneous individualism, what the Chicago School was doing was making the role of authority in society opaque and unaccountable. In the contractual theory, the role of the corporation as an arm of governance becomes unchained from any sort of limits. The result, as David Kipley notes, was that the corporation became a pure creature of the market rather than a creature of government, exempting it from any duty to the public, or accountability to the public, or even publicity to the public, and rendering it eligible for a raft of constitutional rights, including electioneering rights. This neoliberal model of the modern business corporation is, however, wrong, and is wrong in strikingly obvious ways. The formation of a corporation results from the granting of recognition of personhood by a legal system. This institution, a legal entity recognized by authority, is then granted certain rights which include the ability to own property, the ability to enter into contracts and transactions, the limitation of liability of the human agents of the company to any losses incurred by the company, and the ability to issue shares. We can return again to Kipley, who notes that a charter formally ordains a corporation and, as part of this, expressly ordains and authorizes a board of directors, usually with members listed by name, to manage corporate assets, hire employees, define their duties, and generally conduct the corporation's affairs. Corporate Laws Committee 2005, Section 8.01, Section 3.02. It also expressly authorizes the board to issue stock up to a specified amount. Corporate Laws Committee 2005, Section 6.01. All this happens before there are any shares or shareholders. Given this sequence of events, it is clear that the government charter, and not the shareholder, creates and authorizes the board. The share that the shareholder owns is not a claim of ownership of the company. Instead, it is a financial instrument which grants certain rights, such as a potential dividends, voting rights, and some claim to the company's assets in the event of bankruptcy, though there are many classes of shares with varying rights. It is quite obvious that the corporation is not a spontaneous creation of individual shareholders, and this is even more obvious in the case of non-profit corporations, such as tax-exempt foundations or universities which don't have shareholders. However, it must be noted that the example of the university provides us with an interesting situation in that the university can neither be explained by the artificial theory of the business corporation, nor can it be explained by the aggregate theory or the real theory. Whereas the business corporation and the charitable foundation can be traced to charters granted by legal systems, the university, in its origins, cannot, but this does not mean that it forms spontaneously in the sense implied by neoliberal theory. We can see this if we look at the history of the University of Bologna, widely recognized as the first university. The University of Bologna presents us with a problem in that its founding seems to clearly predate any legal charter. The formal date of 1088 given for its creation, that used by the university itself, is unlikely to be correct, and, instead, appears to be a politically influenced date. A committee headed by Italian nationalist poet Giosuè Carducci seems to have chosen this inauguration date of 1088 on the basis of there being a legal school in existence at this time, run by an eminent teacher by the name of Irnerius. As a result, an 800-year jubilee was held in 1888 to celebrate this date and, importantly, to promote national unity. This event was influenced by the desire to help impart historical legitimacy to the newly formed Italian nation. In 1988, this claim was defended in a booklet produced for the 900th anniversary of Bologna University, on the basis that Irnerius' teaching was independent of Bologna's religious schools, which, therefore, distinguished it as a university. This is a shockingly bad argument, and it is quite telling that this is the very best argument that could be advanced in support of this position. More serious attempts to understand the development of the University of Bologna concentrate on the development of student guilds as the basis for the university. The reason for the students having formed into guilds appears to be related to their foreign origin. The students, not being citizens of Bologna, did not qualify for the same rights that Bologna citizens enjoyed, which left them in a vulnerable position. For example, it appears that in instances where a foreigner owed money to a citizen of Bologna and left without paying, this debt could be extracted from another person of the same origin. The difficult position the students found themselves in led them to form a guild, and to begin acting in a collective manner. Initially, these guilds were formed along national lines, but later these nationality-based guilds formed into a unified, collective student guild which was called a universitas. This interpretation of the development of the university clearly places the charter, which was granted by Frederick Barbarossa, after the formation of the university. This sequence of events could be taken as confirmation of the contractual or real theory of the corporation, but this would be a mistake. The students may have organized together prior to the granting of corporate personhood by law, but they did so through a form of organization which was expressly accepted as legitimate by the prevailing authorities in Bologna, even if it may not have been codified in law. The guild was a perfectly acceptable means of organizing in a collective manner throughout medieval Europe. This is an important point to make since the claim of spontaneous organization implicit in both the contractual and real theory of corporations gives the impression that organization prior to legal recognition is completely without reference to the political order of society. Such an organization is considered spontaneous, when, even in this case, it clearly was not. Written law was developed as a means of codifying judgments by monarchs or other forms of authority so that these judgments could be transmitted beyond the personal, but this does not mean that non-codified or unwritten judgments were not binding, and are not still binding. The form of a guild is itself an example of this. The formation of guilds depended on oaths and personal agreements, and not on paper contracts or written legal recognition. So, we can see that it is perfectly possible that a corporation could be formed prior to legal recognition, and yet could still be a product of the express or implicit acceptance of the authorities of the order within which it resides. Perhaps it would be anachronistic to label it a corporation in the modern sense, but nonetheless it was recognized as an abstract entity with privileges and rights accepted by authorities. This is a position which all modern theories of the corporation discount by default, and it is central to modernity that authority cannot have an impact on society beyond the legal, as governance has become synonymous with rule through law. This distinction is a prescriptive one, and not a descriptive one. The example of Bologna University now provides the basis for an alternative interpretation of the corporation, one in which the corporation is the product of the express or implicit recognition of authority, regardless of formal legal incorporation. If the students had formed into an organization that the government of Bologna opposed, then it would have resulted in action against this state of affairs, but it did not. Authority recognized the corporate nature of this organization, and as a result, so did other members of society. So, we can see that with all organizations within the modern world, there is a distinct and noticeable tension between the demands of a politically determined anarchistic thought system and the immediate practical realities of these organizations. These organizations exist, and could only exist, as a result of the acknowledgement of their specific characteristics by authorities. The tax-exempt foundation, for example, is dependent on allowing a great deal of capital to be managed by agents and recognized as such by law, and, therefore, by authority. This authority is also what grants its tax-exempt status. It is inconceivable that this supposed nexus of contracts could grant itself tax exemption, yet this belief is implicitly demanded by the modern theory of corporations. The reason why I raise the issue of tax-exempt foundations in connection with corporations and universities is that while in some instances the characterization of organizations as belonging to a private realm is a means to disempower them in relation to the centralized government apparatus, at other times it serves as a means to empower them. In instances where the formal government apparatus becomes encumbered by blocks to action, the utilization of non-governmental institutions raises the tantalizing prospect of acting in a unilateral fashion under the exceptionally effective disguise of a spontaneous actor. The reader will appreciate the relevance of this as we begin to look at more modern Jouvenelian developments, where it becomes patently obvious that US-based, tax-exempt foundations have been vehicles whereby centralization of power has been achieved on a vast scale. We have previously noted their role in relation to human rights, but as we progress we shall see that their influence has extended into large areas of life, yet, they have generally been exempt from scrutiny in standard political theory because they have been recognized as private actors. They have been considered part of the inscrutable anarchistic realm, which has enabled them to act with impunity with the acquiescence of actors within authority. This we shall see in more detail in the following chapter as we trace the development of modern political science.